Good morning. My name is Valerie Leonard. I am the founder of Nonprofit Utopia. I want to say thank you so much for joining us today. We're going to talk about nonprofit bylaws, and I think it's really, really important that we focus on nonprofit bylaws because there are subtle differences between nonprofit bylaws and for profit bylaws. In fact, some people have gotten into trouble, and I won't say trouble, but they've had their applications to the IRS for tax exempt status to actually be returned to them because they did not include the proper bylaws. They use corporate bylaws versus nonprofit bylaws. But that's neither here nor there. Without further ado, I am going to share my screen and we will get started. All right. As I indicated before, there are instances where people have gotten their applications rejected because they did not use the proper form of bylaws. And we're going to share with you the elements of what should be included in your nonprofit bylaws so that the IRS can, in fact, approve them. If you are a member of the Nonprofit Utopia community, we will come back on Thursday in our nonprofit community private section and we will go over a set of bylaws, in specific detail so that you can tailor them for yourself. All right, the first thing we want to talk about is the Articles of Incorporation. Now, that is important because in so many cases we use terms like Articles of Incorporation, bylaws, and policies and procedures. We use those interchangeably, but they're really three separate documents and they're all important. The Articles of Incorporation are the articles or the documents that you use to file with your state to let them know that you are an organized entity. This does not give you tax exempt status, but it's very, very important that from the beginning that you begin to utilize the language of the IRS, the language that indicates that you are a tax exempt organization. That's another reason why people get their articles, well, not their articles, their Form 1023 or the tax exempt application, get that returned by the IRS because they did not include the proper language from the IRS in their articles of incorporation as it relates to the purpose of the organization, as it relates to how you're going to dispose of assets once you have been dissolved, and other language as it relates to no inurement to the people who actually run the organization. And like I said, we're not going to talk about articles of incorporation, but we're talking about articles of incorporation just for clarity's sake. So the difference between the articles and the bylaws, the articles actually create the organization. And in the state of Illinois, you need to file those articles with the Secretary of State in order to become a legal entity. Filing with the Secretary of State only makes you a legal entity. It does not give you tax exempt status. All right, bylaws, which is the reason we're here. The bylaws, on the other hand, they don't create the organization, but they talk about how the organization will be structured as well as, the overall general rules of the organization. Policies and procedures, they operationalize the bylaws. So they tell you how the board is going to operate on the day-to-day basis, as well as how your management and your programs will be operating on a day-to-day basis. Again, we're not here to talk about policies and procedures. I just thought it would be important to indicate how policies and procedures differ from your bylaws and how the articles differ from your bylaws. So as you think about putting your bylaws together, you will not have gotten the idea that just because you've incorporated, that you have satisfied everything in your bylaws. And you want to also not be confused and think that all the details from your policies and procedures go into your bylaws. So we're going to talk about what should go in your bylaws. First, you should acknowledge that bylaws are legal documents. Your bylaws, if done correctly, they're going to be in alignment with the laws of your state. So that's very, very important. Although the IRS doesn't have specific language that should go into your bylaws, it's good practice to include some of the language from the IRS so that you're in alignment with the tax code. But that's optional, but it's really good to include it. The IRS is going to be using your bylaws to see if you are actually, one, following up or in alignment with your articles of incorporation, which talks about why you are in business, so to speak. They're also going to make sure that as you outline your laws, the rules, that you're in conformance with your proposed charitable purpose. All right, so this is an excerpt from a chart that was done by FormSwift. And this chart, and I'll make sure that our members have this in our community, but this chart outlines state by state um, what the requirements are for the eternal from their attorney generals, as it relates to directors, as it relates to officers, as it relates to members. So in the state of Illinois, you got to make sure that when you develop your bylaws, and this is going to vary from state to state, you must have at least 3 directors. At this point, they're not officers, they're just directors, because at this point, you're just incorporating. You're not legally an entity yet, and you haven't had any elections. The qualifications, there are no specific qualifications that the state puts on the board, but you as an organization may have certain qualifications that you want to have, but your bylaws don't necessarily need to speak to them because it's not required by law. There is no residency requirement, so you can have members from all around the world, directors from all around the world. And there's no membership requirement, although you can have a board of directors where there are members. The term is until the next election, so that could be whatever number of years that you decide, and you're expecting your board members to complete a full term. So that could be a 1-year term, 2-year, 3-year, 4-year, 5-year. A quorum by law in the state of Illinois is the majority of people present. So your quorum in your bylaws in the state of Illinois has to be at least the number, half of your board members plus one to make a majority. Committees, you have to have a minimum of 2 directors on each committee, and the directors have to be the majority of the members if this is a committee that is going to have the power to act on behalf of the full committee. All right. And the only exception for that is when you have a committee that is involved in electing directors. So this committee would be involved in nominating. So this would be like your nominating committee, and then they will prepare the slate, and then they would introduce it to the rest of the committee. As it relates to officers in the state of Illinois, what's required, and you got to make sure that your bylaws are in compliance. They're as defined in your articles of incorporation. You have to have at least 1 officer to certify corporate records, and usually that's your secretary. And your other officers, you have to have 2 or more officers, usually like the president and the treasurer, and you can have more. Two or more offices can be held by the same person if your bylaws clearly say so. Members, you can have a membership organization or not, so that's optional. If you have a membership organization, you have to have an annual meeting, and this must be outlined in your bylaws if you have a membership organization. And if you have a membership organization, this is usually like for associations, professional associations, a quorum constitutes 1 out of every 10 votes. So 1/10 of the people need to be present in order to transact business. All right. Organizational name. Obviously, you're going to have your organization's name. You want to make sure that the name on your bylaws is the same exact name that you have on your articles of incorporation and every other legal document you have filed with the state. The next thing you want to have is the purpose of the organization, and that purpose needs to be consistent with the tax exempt purposes outlined in the IRS code. And if you want to codify or specify which purpose you have, so that people in perpetuity or people coming on to your organization in the future understand that you're not organized just to appease the tax code. They want to, if you want them to know why it is you pull people together in the first place, you'll include things like your mission and then a little bit more layman's language about the purpose. This way, you satisfy the requirements of your state, you satisfy the requirements of the IRS, and you satisfy the requirements of your organization, making sure that you codify the history. Offices, you want to indicate in your bylaws, where your offices are located physically. And if you have more than one office, you want to indicate that as well, and indicate some of the criteria for opening new offices. You also might consider, the dedication of assets article. So you want to indicate here that your assets are going to be used for charitable purposes. And then you also might want to include the inurement clauses and the dissolution clauses of the IRS code. And the inurement clause of the IRS code basically indicates that, none of the profits are going to inure or come back or be for the benefit of officers and directors of the organization. So you can't have people who are running the organization profiting from the organization. And you also want to include the dissolution clause from the IRS code, which indicates that if for whatever reason your organization has to dissolve, how the assets are going to be dissolved. And they're going to be dissolved in such a way that they're beneficial to the community that you serve, as opposed to benefiting people who work there, benefiting the officers and directors. The next thing you want to include is, description of your board of directors. So you're going to have an article about your board of directors, and this will include things like, the powers and duties of the board, number and qualifications, whether or not they're compensated, and generally board members are not compensated beyond reimbursing them for the expenses that they have incurred in service. And you can spell that out in the bylaws. You'll talk about the elections, the terms of office, vacancies, resignation, removals, meetings, minutes, what constitutes a quorum. You'll talk about voting, whether or not a proxy is allowed, whether or not electronic meetings are allowed, and attendance. Now, I do want to say, this is where people get in trouble. One, they might be too vague in their description, so they might not necessarily address all of these things, but if they do, they might do it in such a manner that it's vague and it could cause confusion. Or the biggest problem is people have these tight bylaws, but they don't adhere to them. And not adhering to your bylaws is a good recipe for dysfunction. So you should make sure that you bring your bylaws to every board meeting. Every board member should bring their bylaws. Your next article should include officers. So you want to describe the duties of the officers. And then you might want to have an article about committees where you're outlining the types of committees, how they'll be created, what their membership will be comprised of, and the authority they have, whether they have authority to encumber the whole organization, like, for example, your executive committee, or if they primarily make recommendations for the full committee or for the full board to approve. The next thing you want to look at is the standard of care. And here, this is not required, but I think it's a really good clause to include where you're outlining the general duties of care. So you're kind of reminding people of what their fiduciary duty is as board members, reminding people that their duty of care is to carefully consider every matter that comes before the board, taking into account all of the data that you have in front of you, and it might require the use of experts, the use of staff. So you want to kind of outline generally what that looks like. You also want to outline how the board, what the board's authority is in terms of loans, the conflicts of interest, how you're going to handle conflicts of interest, what constitutes a conflict of interest. If you're in a situation where there are people you want to bring on board who have conflicts of interest, this is really something you should avoid. But if it can't be avoided, you need to um, probably have something on, have a clause that speaks to the restrictions on the number of interested members. And when I say number of interested members, that is, the number of people who might have a financial interest either in the organization, the outcome of organizational decisions, financial interest in contracts, et cetera, et cetera. You want to put restrictions on that. And the reason why that's important, and like I said, ideally, you really don't want any conflicts of interest. But if in the event it can't be avoided, you want to have restrictions on the number because you don't want the IRS to come in and dissolve you because it appears that you're in business not to serve the community, but just to enrich people who work for the organization or serve on board. So you want to cover yourself or prevent a situation where that can happen by having restrictions on numbers of interested members. You also want to have procedures for disclosure of potential conflicts of interest, how you're going to handle it. If in the event that there is a conflict of interest, how will that conflict of interest be resolved? You want to have procedures for recording those transactions in the minutes. Why? You want to memorialize anything that could come back to bite you, right? So you want to carefully document um, why you're actually doing business with someone who has a potential conflict. And the same procedure would happen with self-dealing as well. That's when a board member, you're doing business with a company or an organization that a board member either owns or is a board member of. So you want to outline what these conflicts are, um, and then how they are being addressed. And you want to make sure that there's documentation, like disclosure forms. You want to document the votes and why exceptions are made. All right. And then you also want to have an indemnification clause in the event that any board member causes harm to the organization, how are they going to indemnify people? And likewise, if in the event the board members are carrying on their duties and they're sued and there's a potential loss for them, how are you going to handle it? And usually, directors and officers insurance can go a long way to help that. All right. You also want to have articles as they relate to execution of corporate instruments. And, that could be things like your checks, mortgages, deeds, loans, other loans and other contracts. Who is actually going to be the one to sign? Is it the president? Is it the board president? Is it the executive director? If it is the executive director, what's the limit of his or her authority? Will there need to be co-signature by a treasurer or another person? It's also a good idea to have an article on how you're going to deal with records and reports, right? So this section would describe the types of records and reports that are maintained, and you probably want to go in even more details. So your bylaws is not the place where you go into a heck of a lot of detail. You do want to give a framework. If you want to provide detail, it's really important to have a document retention policy. And in fact, the IRS has a sample document retention policy that your board can use and, tailor it and adopt it, right? So the types of records and reports that must be maintained, this is a short list, right? Include things like your articles of incorporation and bylaws, Form 1023, which is the document that you use to actually file for tax exempt status. These are permanent records. Form 990s are permanent records. Your audits are long-term records. And then, there are other records that are long-term, such as human resources records, as opposed to permanent, like articles of incorporation. Those are records that you must never throw away. So you'll create a document retention policy that will indicate, which documents are permanent, which are long-term, which are short-term, how long you need to keep them, and how they should be destroyed. You need to also have a section on the fiscal year. So basically, this is going to indicate when your fiscal year will end. Will your fiscal year be the same as the calendar year ending on December 31st? Will it be August 31st? Will it be June 30th? Will it be March 31st? So just indicate when your fiscal year will end. And from that point forward, all of your financial records are, you're going to have a year-end close, for closing your books on the 30, whatever that fiscal year is. And, you'll also do the same for your 990. At the end of your fiscal year, you have 5.5 months to file your Form 990. You should also include how you're going to deal with amendments and revisions to the bylaws. So you should actually describe what that process is going to look like. How does it work? Sometimes you might include what would trigger such a revision. And usually you want to look at your bylaws, once a year to see if there's a need to change them. You should also consider a section on your corporate seal, whether or not you will have one, where it will be stored if you have one. And then finally, you should have a place for certification, and usually this is filled in by the secretary, is indicating that these particular bylaws were adopted by the board on what date, and then the secretary will certify that. And once it's certified, if you don't have your 501c3, you need to include the certified copy with your application to the IRS for tax exempt status, because they want to make sure that you're not just adding stuff to the packet that has not been approved by the board. Anything that's been approved by the board is also encumbered by, or they're obligated to live by. So it's important that you're providing some, a signed copy certifying that they were actually approved by the board of directors. And you will do the same thing in the event that you have to amend them. So if there's a resolution that calls for changing, one or two clauses or articles, you'll have to also make sure that those are certified as well. All right, so if there are any questions or comments, please feel free to share them and also indicate who you are, where you're from, if you have any experience working with bylaws, let us know, share what some of those experiences have been for you. All right, so it doesn't look like there are any questions. I will hold on um, maybe a minute or so more to see if there's anybody who's going to um, chime in, introduce themselves, let us know if you have any questions or any of that good stuff. Again, if you are a member of the nonprofit Utopia community, we will be going over, a real set of documents on Thursday at 9 o'clock, Thursday, December 7th at 9 o'clock in the online community where you can, get a copy and you can mark it up yourself and tailor it for your own use. All right, so it doesn't look like we have any comments. So I'm going to end right now. Thank you so much for joining us. And you can always refer to this live stream on our YouTube channel.